Well, thank you very much. I've never been welcomed so often and so intensely. So it feels good to be here. Thank you. Also, this room has a nice feeling to it. It's not my first time I'm in Canada. I've been here before, years ago in Vancouver, with, at the invitation of Anne Mullins. I don't know whether that's a name that rings a bell with you. She did research in Holland, and I took her under my wings, so to say. I introduced her to colleagues, to nursing homes, and to the people who were active in the AIDS therapies at the time. She was also introducing me to Russell Ogden, a name I hope is not really too far away from you. I don't know whether... Yes, thank you. Also from Vancouver. So I've been here before. The weather at that time was good too, also in October, I must say. Vancouver was beautiful. I've been in Toronto with Professor Singer. I don't even know whether he's still alive. He was a rather old man. He's still alive, okay. He invited my colleague Evert van Leeuwen and I to speak in a church on euthanasia, and I thought that was quite peculiar. And that was a memorable meeting. We had dinner with his family at home, and that was really a good memory. Since then, I haven't been in touch with Canada, only with the exception of being involved in Carter. And I was interrogated by the prosecution from Vancouver right there and then in Amsterdam by a video. And I felt guilty almost because they attacked me on my writings as if I had been personally responsible for ending life and all the things that go with it. So Canada really is not a strange feeling for me. I feel like I'm coming home a little bit. What I'm going to talk to you about is what the Dutch history of medical aid in dying. I think that is maybe fundamental to understand what you are doing, and the difficulties that you are being confronted with are far different than how it came across with us. So I think it's good to have that understanding in order to be able to place the Dutch development as it gradually came about instead of being confrontational as it is so clearly in your country. I will talk also a little bit about the differences in the laws and their possible effects, a little bit because I'm not a lawyer, I'm a philosopher. So I'm humble in that respect, not in many others. And I will talk about key issues that I think you will have to address, or you are addressing already. Not about the Dutch definition. Actually, what is the most interesting part, I've been a student from 1964 until 1974. In 1974, I received my medical degree. That was exactly the time that the medical profession, that physicians started to talk about euthanasia. And they started to talk about euthanasia not because they said that we are all in favor of it, but we knew that some of them, oncologists more often, were in the position that they ended the life of their patient actively because the suffering was unbearable. And the Dutch medical profession wanted a debate about it, wanted a discussion, wanted it to be acknowledged, and they wanted to protect the physician. But there were divisions. There were divisions along religious lines. The Roman Catholics, the Christians were against accepting euthanasia or assisted dying. A minority, actually, of the physicians were in favor of it. And over these years, and I'm taking a great leap to today, over these years, the Dutch situation is that 9 out of 10 physicians are in favor of assisted dying. So there's quite a bit from 20–30% to 90%. And that's because we had a practice, and the practice developed as it did in a supportive way. Physicians felt supported by it. But nowadays we do have a division again, and it's at the end of my presentation you will be able to understand why. The model of the suffering patient in the 70s was the cancer patient without treatment options, suffering unbearably. And that model had at least a certain percentage of physicians supporting an active end of life. And what we see now after the developments we've had, the model is still the cancer patients, but there have been shifts, including psychiatric patients and including Alzheimer patients, and even more surprising to my experience, the patients with accumulating diseases or disabilities or limitations of the elderly, who also qualify according to our procedures. And now, what we see now is that a minority of the physicians in Holland will support the option for the elderly. And a bit larger group, 50%, will support the options for psychiatric patients and euthanasia patients. So we still have a division. We still have let's say, a medical body that supports all these options. And I find that a very interesting thing from a historical perspective, but also to see that it's still dynamic, it's still going on. The Dutch medical profession came out first in 1984, proposing consultation prior to any acts of ending life. They focused on competent patients, cancer patients, but they also, right from the beginning, were aware that that is not the end of the issue. That psychiatric patients, Alzheimer patients, and elderly also develop diseases that cause unbearable suffering, and that also neonatals and also people with a double handicap, mental and physical, also come in positions that they are suffering unbearably. So from 1985 on to 1997, there was a committee that has written a very nice book, and the conclusion was, in general, that these actively ending of life should be possible, but the expectation was that the cases should be rare, and that is where they went wrong. They did not know what happened actually. Fundamental for our development is that the medical profession instigated it, but the judicial profession supported it actually. Since 1974, I'll tell you in more detail about it. So one of our analysts actually of the Dutch development, an American sociology of law professor in the city of Groningen, made a conclusion that I support wholeheartedly. He said rules and regulations were largely worked out within the medical profession before being adopted in case law and regulations, with a focus on medical ethics and medical science. The idea was that there was a unity in the medical professional conceptions, medical professional morals. And in fact, what we see nowadays, that is not true. There is no unity. The first court case came from 1973, Mrs. Postma van Boven. I will go into some detail, especially because it's very peculiar that how this cause went about. The focus of the court was not on crime, as I said, but on how medicine deals with extremely ill patients. The president of the court asked the provincial director, and you know what provinces there are, we have 11 in Holland, the province of Friesland. He asked the medical inspector, what do physicians do at the end of life if their patients are suffering? What do they do? And he described what physicians do. They gave morphine at the end of life in increasing doses until there was the option of a depression in breathing, and because they did not provide any food and liquids, no intravenous solutions, patients would die. Otherwise, they would just prolong the dying process. That's what he described. And the court came up with the conclusion that Mrs. Postma van Boven was convicted because she had injected her patient with 200 milligrams of morphine at one time instead of the gradually increasing doses. So she had not followed medical rules. What's even more interesting was that You know the law, the symbol of the law is a lady Justitia with blindfolded. The law looks at several facts and disregards others. The fact that she was not the physician in charge of her mother was disregarded. The fact that she was not clearly not in charge, but she just happened to come by to take care of her mother because the general physician who was in charge did not want to do it. So she actually fell in, so to say. The Leeuwarden court, where it all took place, defined 5 conditions for acceptable euthanasia: incurable disease without prospect of improvement, suffering that is subjectively unbearable for a patient, a clear request, possibly in writing, a terminal phase has arrived or is imminent, but even the aspect of the terminal phase in the Leeuwarden court was debatable because they realized also that suffering also exists in patients with chronic neurological diseases like multiple sclerosis or Lou Gehrig's disease. And it should be only by a physician in charge preferably, or after consultation another physician. In Leeuwarden in 1974, the issue of referral already in the Netherlands started out. And that certainly is an issue with all of you here, I understand. There are 3 Supreme Court cases that are important. I know all of these people. Schoonheim was a colleague at the university, Chabot became a friend, and Sutorius was a colleague in the same area where we function. Schoonheim, the first court case of the Supreme Court, led to the conclusion of our Supreme Court, not the lower court of Leeuwarden, that euthanasia was possible because there was a conflict of duties. The duty to alleviate suffering and the duty to protect life. The duty to alleviate suffering led to the caving in of the duty to protect life. And the court said that is in a given situation when there are no other options, it's acceptable. In Chabot 1994 concerned a lady in her 40s who had lost 2 sons, one a suicide and one by cancer. She was divorced and she did not want to continue living. She was not clinically depressed. She was not hospitalized. But she was a very sad lady with a bad life who wanted to have her life ended. And Chabot consulted 7 colleagues, psychiatrists, psychologists, and all of them said that given these situations, that it was the right conclusion to help her die. And he helped her die. He reported himself. He was actually supported by the Dutch Euthanasia Society, the pressure group, and the Supreme Court convicted him. They said, we feel that you are a person of integrity, but you should have not only consulted these colleagues in writing, but you should have brought them in touch with the patient. And that's why we convict you of 1 week. We cannot allow a total letting go. So the conclusion of the Chabot case was that suffering, not only physical suffering is acceptable, but also psychic suffering, mental suffering. Because the court said that the source of suffering is not the fundamental issue, but the measure in which the suffering is being experienced. So that is how the suffering became one of the central focus of the Dutch regulations. But there was the danger, if any type of suffering goes, that someone who would say, I suffer even though I have no mental disease or a physical disease, but I suffer unbearably, I want my life to be ended, that could be, in theory, a possibility. So the next court case came in 2002, describing an elderly man who was suffering, who claimed to be suffering, but who was just having physical limitations of the elderly. The Supreme Court at that time said that suffering must have a basis in a medical classifiable disease. So not anything goes, there should be a medical classifiable disease. So that limits it. Chabot expanded the area, and Sutorius limited the area again. I'm going to skip some of my slides in order to have more time for discussion, because this is of secondary importance. It's important to define the role of politics, because with you, your judicial system, the Supreme Court has been, let's say, the major part to cause the changes that you are confronted with. One would expect politics in a democratic society, that politics would play an important role, but they did not. We had a constant opposition from Christian Democrats, supporting liberals and divided socialists. And we had a crucial period in 1984. As I said, the Dutch Medical Society came out in favor of euthanasia. There was a law proposal by the liberals that was defeated, but put it on the agenda. There was a lenient Supreme Court decision, the Chabot case. And there was a supportive report of the State Committee on Euthanasia that said it should be allowed. It was a state committee that, there was also a minority report reflecting the division. The two Roman Catholic members of the state committee wrote a minority report. I knew these two personally, and I could understand why they were opposed. So what did the politics do? And that is typically Dutch, that you may remember that. Typically Dutch, because if there is a dilemma that politics cannot solve, they try to depoliticize the issue. What they do, they appoint a committee to study it. And that was right, because there were all claims. There were claims that 50,000 people were euthanized every year. But nobody knew, because there were no investigations whatsoever. So the research committee, Medical Practice on Euthanasia, made an inventory of all medical decisions at the end of life in 1991. And it proved to be that the numbers were low. But the fact that the research committee made such a giant step forward caused it to be repeated every 5 years, and we are waiting for the report, for the numbers, the data of 2050 now. This is what you do not have in Canada so far. And this is really, if anything you should do, you should adopt and accept a procedure like that. It costs a lot of money, but the data, the amount of data, and the political, the effects of the data are clearly, undeniably positive. Now, how does the Dutch law look? The Dutch law, compared to your law, is very short, actually. The law is physician-centered. It's still illegal to have euthanasia and assisted suicide, except when you are a physician and you're a patient of a physician and you request an end to life. So there must be, the physician will not be prosecuted after mandatory reporting. That makes it also kind of a funny law. If you have a law against breaking in, you will be prosecuted because you have not reported the break-in. That is, from a legal point of view, is also, you have the, you lawyers know the word nemo tenimur, huh? You are not obligated to report yourself, but in Holland you are with this type of law. If there is a voluntary and well-considered request, that used to be differently worded, but now this has been the result. There's unbearable and hopeless suffering. The patient is fully informed. You recognize that, of course, in your law. There are no reasonable alternatives. And in this case, in our case, for both physician and patient, so this is a relational aspect, while in your court, the focus is on the patient. In your law proposal, or your law, the focus is on the patient. There is an independent collegial consultation, and ending life with due care with prescribed means, and the means are quite clear. No, a major difference with your law is that we have had an advance directives article from the beginning, Article 2.2, for incompetent patients, and I'll read it to you because it's interesting to reflect on it. If the patient is over 16 years and no longer capable to express his will, but prior to this condition was deemed to have a reasonable understanding of his interests and has made a written statement containing a request for termination of life, the physician may carry out this request. The requirements of due care referred to in the first paragraph apply mutatis mutandis. This article has been introduced into the law by the Secretary of Health, Mrs. Borst herself. She was a member of the Liberal Party, and she wanted Alzheimer patients who lost competence to have the option, through an advance directive, to have a life ending of their choice. And it has become a divisive element between the state and the Royal Dutch Medical Society. Nowadays, from the perspective of progressive liberals, the Royal Dutch Medical Society, who started it all, now is being considered a conservative faction, actually. But I agree totally. I personally agree with it because I find it impossible. I do have Alzheimer patients in my practice. Actually, the last euthanasia I did less than a month ago was an Alzheimer patient, but that patient was clearly aware, in spite of all the breakdown, and all the loss of memory, all the loss of motor agility. He was clearly capable to understand what he wanted, and he felt his life was so worthless at that time that he asked me to end his life, and I did it. So we could communicate about it. And the fact that communication should be possible up to the very end, that is a fundamental difference between the state, the euthanasia committees, and the Royal Dutch Medical Society. I agree with the Royal Dutch Medical Society. I side with them, so to say. Now, if you look at the nature of our law, the law is physician-centered. It was a codification of the previous regulations. I did not show you, but you have to accept that. But in addition, it has the option for incompetent patients. It's relatively short, only with amendments in criminal law for now possible aid in euthanasia and assisted suicide, without referral to punishments in case of non-compliance, as is not in your law, putting criminal procedures at even more distance than before. So the idea was not to have criminal, let's say, winding, not criminal breathing in this law, because that scares physicians away from it, and that makes it ambivalent to participate in it. That was at least the idea that we had. We have euthanasia review committees in our system that you do not have, who have now, within this law, the final say also in the cases of psychiatric diseases and incompetent patients. And we have an obligation for yearly reporting by these committees through to the public, the Minister of Health and Justice, but also to Parliament, describing all the complex cases that they dealt with in a given year. So we have several safeguards that I will describe now. We have a medical consultation. The medical consultation is before a physician ends the life, of course, but it's also an issue of timing. And the timing, I understand, is also of concern for Canadian physicians, because you still want your patient to be aware and be able to communicate with the consultant. So what the aim of the consultation is to check whether the legal conditions are complied with in order to protect the physician. And then after the intervention, after the ending of life, all the material is being sent to a euthanasia review committee, an ERC, in short, for each of the 5 judicial regions, 1 committee with a lawyer, a physician, and an ethicist. I am a euthanasia consultant. I've been one from 1979 on as the first group in Amsterdam developed. We now have more than 600. I will talk about that a few slides later. And I've been a member of a euthanasia review committee for 10 years, from 1998 to 2010. So I've seen I've done hundreds of consultations. I've seen thousands of euthanasia cases in review. Now, because the increase in numbers has been so large that every review committee in one of the 5 regions, 15 people, have 2 subcommittees, so they are each now, there are now 45 people, 3 times, 5 times 3. The numbers have increased from a low 1800s to 5,516 in 2015. About the safeguards, independent consultations. Originally, the case was that any physician could qualify. And what we saw in practice is that that pairs developed. In several cases, one physician would be the physician who ended life, and he would ask physician B to be his consultant, and when physician B would end the life of the patient, physician A would be a consultant. That things like that developed, and I can easily understand if you have someone you trust, someone you like, who's a trustworthy colleague, that's the person you want to have as a consultant. You don't ask someone independent whom you don't even know whether he opposes it or not. So that's how it was in the beginning. Since 1997, we have specially trained consultants by the profession. As you said, we have now the SCAN organization that is organized by the Dutch medical profession. That is something that is highly valuable. You don't have that in Canada, and you may think about organizing it. To be a consultant demands special qualifications, demands a special model. You have to know what to look for, how to deal with it. And you need special training, and you need to do it repeatedly in order to do it right. Otherwise, your learning curve will be so low that you have to develop it all over again, each time again. So the function of consultants is not only to do the consultation, but they provide answers for physicians to questions or problems, and anything in relation to the end of life. They give consultations with the patient on a short note, report in writing 24 to 48 hours. So it means actually when I'm on call as a consultant, I'm on call with 3 or 4 other consultants for a given week. We divide the week and I'm available. I'm being called. I give a call back to the physician. We talk about a case. I give a first interview, a long interview. I ask for the medical records of the patients. And when I have these records and I feel I'm informed enough, I go to the home of the patient whose life will be ended. I talk to the patient, I talk to the family. I need to talk to the patient alone also in order to really know that there are no familiar pressures, for example. I go home, I write my report, and sometimes that can be done within a day. So this is a procedure that really is flexible and also fast. And I feel that we are doing a good job of that. The consultants are in regional groups. They see each other at least 4 times a year, but they are when they are on call, given a week, they are in constant communication about questions they have. So it's really a very lively situation, and it's really an honor to be one. The ERCs, the Euthanasia Review Committees, have a lawyer chair, a physician, an ethicist, as I said, and they are supported by a state-paid staff of lawyers and secretaries. You get paid by the state if you participate in work like that. They meet monthly, have a lot of homework, discuss individual cases, especially the complex cases and unusual procedures. And it's very interesting. They are not a police in a committee. They are a committee that trusts the medical profession, the physician and the consultant, to provide adequate information so that they can do their work, to check whether the legal conditions were followed and the case falls within the limits of the law. But sometimes physicians do not give enough information, so they are being invited first in writing. And if the written information is inadequate, they are being invited to come and appear before the committee. It's just like a coffee table, actually. But physicians are scared of that. They feel pressure, they feel tension if they have to appear before the review committee. Because physicians in general do not like to be looked over their shoulders and don't like to be approached and like to be assessed. So that is the feeling. And I've been on both sides, and I've been impressed how much the committee was actually siding with the physician and trying to understand what the physician did. And that's also why a physician is so important in a committee like that. They have published a code of practice since 2015, also in English, so you can find it on the internet. What the review committees do is they find the limits of the law, also with psychiatric and Alzheimer patients. In the period that I was part of the review committees, we saw the first cases, and I was deeply impressed actually by the length of time that it took for a psychiatric patient to receive an end to their life. There were endless consultations, endless. Sometimes I thought this is almost bordering abuse, actually. But it means also that physicians did not like to do it. But the patients would continue with their questions. The same happened with multiple ailments of the elderly. The first cases I remember vividly. An elderly lady who was immobile, whose real pleasure in life was to read books, lost her sight. An old man lost his ability to hear while music was the pleasure of his life. So these people convinced a physician, and that is the second bullet. These people convinced physicians that their suffering was indeed unbearable. So you have to realize the ERC set the limits of the law, or find the limits of the law, but they do nothing else than reviewing what physicians present them with. So this is a very important understanding. People see sometimes review committees as let's say, creating new possibilities or new shifts, but actually the medical profession does it. In 2015, to give you an example in numbers, in 2010, it was 3.9% of all cases. In 2015, or 2010, it was 2.9%. In 2015, 3.9%. Quite an increase. There were 109 cases of dementia, early Alzheimer's only, 56 psychiatric patients, 183 patients with multiple ailments of the elderly. No cases of dementia were judged without due care. And in 2011, there were 2 cases of dementia patients not competent at the time of ending of life. Those descriptions, once it became known, showed also the weakness of the review process. Because when journalists got hold of the actual descriptions of the case, there were much more moments that I find problematic, for example. And I thought that should not happen. So I did not side with my colleagues at the time, and I've come to the conclusion that it's almost impossible to have a satisfactory ending of life with Alzheimer patients who have full-blown Alzheimer. That is, as a physician, I wouldn't be able to do it. Certainly not. Now, if you compare Dutch and Canadian law, the Dutch law is physicians and suffering-centered. The Canadian law is patient and disease-centered, focusing on a balance between autonomy and vulnerability. The Canadian law focuses on not discriminating against the sick who are unable to take their own life and aims to protect those against legal consequences. That actually is a very interesting. One of my first research items was finding out what are the arguments over time from, let's say, the 1800s, beginning of the 1800s, until this day. What are the type of arguments that are being used either in favor or against euthanasia? And we've never come across an argument like this. And it was an argument that was formulated by lawyers, which I find even the more worthwhile. It actually is also a pro-life argument, because the idea is that you should not force people to end their lives before their time of their own choice have come, and when they may not be able to do it. So it's actually a very interesting start from your Canadian Supreme Court, I think. In the preamble, it becomes clear that the law is open with respect to realize that there are certain items you still have to take care of. And it's good to realize that. As a Dutchman, I will say that introduces inequality here and there. Inequality for your Alzheimer patients, inequality for your psychiatric patients, and maybe other groups also. But it's quite clear that Dutch law keeps criminal law at a distance. That is what I find interesting and good about the Dutch law, even though from a legal point of view, from a legal philosophical point of view, actually, I think the law is crazy. It's open definitions. How can a law have open definitions? But the real question is also, does your law have open definitions or not? Yeah? And that is, that's worthwhile. The Canadian law is more rigid and detailed and exempt in many participating persons. I mean, we've never had that. Our pharmacists feel neglected, actually, when they look at at the importance of their work in your law. Eligibility, specifying an adequate request in writing, you don't have to have it in writing. I've written an article that you could write it at the back of a beer pad, for example, that if you want to, and that has legal quality. You don't have to have it in writing. If I can find it in the medical records that your physician and you have talked about it several times, and that you stick to your request, that is adequate in our situation. So we do not, this breathes a kind of distrust, but maybe I'm over evaluating it. Communication problems are dealt with, and a stand-in for signing, that we don't have that either. Specifying the conditions of independent consultation. And comparing Dutch and Canadian law from another angle is the central condition of the Dutch law is unbearable and hopeless suffering. The Canadian law focuses on disease. And I'll go through it because what I said about having an open definition, I've heard several stories about it. You either have a serious and incurable disease, illness, disease, or disability. The disability is almost similar like the group that we have of the elderly with let's say, accumulated disabilities, accumulated limitations, are in an advanced state of irreversible decline in capability. Who is going to be deciding that? That may be cause for conflicts between physicians and patients. That causes enduring physical or psychological suffering that is intolerable to them and that cannot be relieved under for them acceptable conditions. The Dutch law, as I said, it's relational. Doctor and patient together have to decide. Here, it's the patient who decides. And I would be interested to hear how physicians feel about it, because often I've been in the position that I feel that there are still medical options for a patient, that the suffering does not have to be as unbearable as it is at the moment, that there are treatment options. And I argue well, to be honest, I mean, but I argue with my patients until we have an agreement, because they understand that I don't like to do it. And if I'm going to do it, I have to be behind it 100%. Otherwise I won't do it, because I will have to continue living while they are dead. I will have my conscience while they are dead. So I have a clear opinion on that. In your statement, natural death has become reasonably foreseeable, taking into account all the medical circumstances without prognosis necessarily having been made as to the specific length of time that they have remaining. If you look at this, if you read this and you take a liberal position, that is a very open statement. Anything might go, because death is not foreseeable. Well, What do you mean by it? I've learned also that physicians are occupied with the fact that they do not want to be confronted with a very open approach. They want to have a clear description of when it is possible or not, or when they should participate, or when they are free not to participate. And so to be very honest, when I read this, I said, it looks like it's limiting, but in fact it can be interpreted also like a very open approach, just like ours. And if that is a reality that the Canadian public is going to realize, then you will have your shifts in requests for euthanasia outside of cancer also. There's no doubt about it in my mind. Well, the Dutch law has an advance directive. The Canadian law, the government intends it to develop it in the areas of mature minors, advance requests in general, and in the case of mental illness. So that is still to be done. But if you compare the safeguards now, I'll go through it quite quickly. The Dutch safeguards, request, consultation, and the review committee afterwards. The Canadian law actually has a safeguard with the request and with the consultation. And there's a waiting period of 10 days or less, and there are more countries where there is a waiting period. But having a waiting period may be problematic for physicians and patients. And there's also an opening to limit the waiting period, but then again you have to go through another option again. So you're not making it really easy for your physicians. And if I were a Canadian physician, I would feel irritated, to be very honest. In Holland, the public and the government trust the medical profession. This may be interpreted as a sign of distrust. Well, ensuring the independence in the Canadian and the Dutch law. The Dutch have the model of expert witness in a court proceeding. No financial, no hierarchical, no familial relationship, and everything else goes. Here, the descriptions are limiting because there is an exclusion, and the aim of the exclusion is that there should not be any hanky-panky around. And I can understand that, but we don't, our approach is not founded on there being hanky-pankies, so to say. Some key issues. The issues of suffering. Why do physicians refuse in 2 out of 3 cases? That is still the case. The last time it was investigated was in 2010, and I will be interested to find out in 2015 whether we have the same numbers or not. The reasons were there were alternatives, including pain treatment. Suffering was not unbearable. Request was not really well considered. The absence of a correct view on the disease. Request was withdrawn, well, that is quite clear. And objections in a particular case or in general against euthanasia or assisted suicide of the physician. So if you look at these descriptions, they are open for questioning. Suffering was not unbearable. Who is the judge of that? Does a patient really have to be in extreme suffering in order to qualify for assistance in dying or not? Or may the patient just know that it's coming or not? That is one of the things that we focus on. Unbearable suffering, the analysis of it makes clear that there are 2 different takes, 2 fundamentally different takes by physicians and patients. Physicians tend to focus on physical symptoms, loss of function. Patients focus on the whole of their situation and the future. So patients experience anything in what will happen next week, next month, how will it be? Physicians tend to focus on being bedridden, being dependent in need of almost total care. Patients tend to focus on preventing these stations, focusing on remaining in control and having a death with dignity. There's very few literature on refused cases, but the little literature in the British Medical Journal that has been published makes clear that some physicians find it unimaginable that you could end the life of a patient who opens the door him or herself to let the consultant in. Or a patient who does groceries. Even for some physicians, that makes it an impossible case. And as a physician, I can side with it, but I also see the problematic side of it. So the assessment of suffering is the central item. And one of my interesting papers was actually on how do we assess suffering, how have we learned to assess suffering, and it's a cornerstone of physician-assisted dying. Suffering is an experience, it's love of hope, joy, sadness. Suffering is therefore existential, and suffering is not subjective, as many people say, but suffering is personal. It's a function of the person. That is what you always should remember. Human beings exist in time, have a past, a present, and ideas about their future. Therefore, one needs to understand their take of their suffering, because they are the person who is living in time and whose time is limited. Within the context of physician-assisted dying, the assignment is to understand the nature and the depth of their suffering. I call it objectification. In order to understand and share in it to a certain extent, one needs a different relationship, repeated interactions, and observations. I think that with this description of suffering, I will stop because given the time. One of your persons already left. He suffered too much, apparently.
That's right. Unbearable.
Unbearable. Okay. The conceptual frame of assessment that we use, that I described, has two sides. An empirical side, giving, as physicians do it, the actual suffering, complaints, symptoms, loss of function. But the other side is the hermeneutic approach. What does it mean for a physician? I'll give you one example. A physician or a patient who is very stingy, very clean, has a psychiatric condition of not tolerating filth, for example. For that patient, becoming incontinent is an entirely different issue than if that it doesn't matter much to you. So you really have to personalize the suffering and make it part of the biography of the patient. Well, those are some items, and there are many more, but then we probably would sit here at 9 o'clock tonight also.
Well, maybe some questions will help continue to clarify. So I invite you, maybe when you go to the mic, to identify yourself, and we can start with.
The students can also hand the mic around. You just want to stick your hand up?
Yes. Well, sure. If you don't want to go to the mic, there's someone. Good.
Thanks. Thanks very much, Dr. Kimsma. Eric Wazelenko, I'm a palliative care physician and clinical ethicist from Alberta. I appreciate your insights and your experience. Two quick questions, and one may be harder to describe an answer to. In the early slides, you described that one of the criteria was an incurable disease without prospective improvement as a condition. In the Canadian law, we've heard repeatedly from the courts and from government the reassertion that Canadians have always had the right to refuse legitimate standard of care treatments. And so a patient can refuse that treatment. The condition would have been curable if receiving those treatments, but because the patient has decided they don't want to access those particular treatments for whatever reason, their condition would become incurable. So is that an issue in the Netherlands or not? And I guess the second question would be, why do you think the numbers are expanding in the way that they are?
The second question.
Why do you think the numbers of people accessing assisted death are expanding the way they are?
Okay.
Thanks.
Yeah, we've had the issue of refusal, of course, and one of the approaches was that the measure that was refused should be proportional with respect to the effects for the patient. So it would be very acceptable if a patient would refuse another chemo, and then you have to take it from there as a physician, as a palliative care physician. The same here, probably. But there have also been cases that patients refused, for example, morphium, because they had ideas about morphium that date back to the fact when one of their parents died, they got morphium, they got delirant. They got into a delir. So that showed me, at least, how far back the memories can go, and how far back medical experience with the death of parents go into your own assessment of your position. So the approach is then to argue with the physician, with the patient, to show the patient that it does not necessarily have to have the same effect in you, and to propose a try out. I've had one case which I thought the system really went bonkers, so to say. There was a man, one of my colleagues as a consultant had that experience, a man who had COPD, constructive lung disease, and he wanted to die, and his physician had asked for a consultation, and the consultant asked him, why don't you use oxygen? Because oxygen is the most effective approach in that type of disease. And the man said, I don't want to be an invalid with a bottle of oxygen on his
On the side or
on the side. And when my colleague, the consultant, said, well, I don't understand that, but I will tell your physician that this may be what is still an option, could be an option, the man committed suicide. And the physician was accused by the consultant was accused by the family of not having functioned properly. And the committee that made the assessment, there are also committees to handle complaints of consultants. I mean, it's really high level industry. The committee found him guilty, actually, because he should not have said that, because it was known before that the patient did not want oxygen. So that is a peculiar exception. That's not the rule. But the rule still remains, you argue with the patient. And if the patient really does not want to accept an intervention, then you have to take it from there. But sometimes, in my own experience, that I have sometimes refused a patient and said, if that is your take on it, then I will have to tell you that my participation and my promises to help you might end here and there, because, as I said, I have to live with it also. So I'm taking you seriously. I want you to take me seriously also in my duties and my obligations.
The second part of the question was, what explains the increase?
Yeah, the increase. Well, one of the explanations that it really has not been investigated. Maybe there will be remarks in our 2015 state report. But, you know, euthanasia and assisted dying are topics that are not daily, but certainly weekly in the papers, on television. So people talk about it. It has become the talk of birthday parties. So it's expanding, really. And to be very honest, I find that a good thing, because I'd rather not have ignorance about it. Actually, when my wife and I came into Toronto 2 days ago, the officer at the gate, letting us in or not, said, where are you from? I'm from Holland. He said, what are you going to do here? I'm going to give a presentation. What are you going to present about? I said, medical assistance in dying. And he remarked, do they have that in Holland? I looked at him, clearly realizing that he hadn't read the foreign pages in his paper yet. I want to make clear that you have a lot of education to do also with respect in this respect, because death is not an exception. All of us are going to die. It's what shares us, or what we have in common also.
Au microphone, and then Madame.
Thank you very much. Thank you very much for a wonderful talk. Rob Cameron from McGill University. So just a quick question. I'm really intrigued, and I can see the benefit of the research committee for medical euthanasia. Can you expand a bit on the details? Who appoints these people? How are they funded? What data do they collect? And how do they do that?
Well, they are appointed by the government. There's a procedure to select them. They have to qualify, and the material they get is all the reports of the physicians, and the reports of the physicians are regional. So that is what they have to deal with, and there are models actually, and the models are the basis for the assessment. In the models are the questions with respect to the conditions of the law.
Okay. Okay, thank you.
So it's a lot of paperwork, I can tell you. Sometimes I thought I would become a paper pusher.
Yes, you have a question?
Okay, first of all, I would like to make a couple of comments. This way of handling end of life is not good, because breaching the prohibition against killing is turning our hospital into places where they are healers, all right, but also serial killers. The real humane solution to that is palliative care. Now, modern medicine is advanced enough that practically all pains can be controlled with powerful drugs. I mean, this is, and it's chilling to have a presentation like this, as if they were talking about the more normal aspects of medicine or medical law. It's not good when a society starts. I'm not talking about Holland, but here in Canada, we desensitize ourselves to killing like that. Also, these kinds of laws will also threaten people who are vulnerable, people who could be the victim of vicious relatives, or who could be put under undue pressure to do that, or all sorts of things like this. So this is, for you people, start to wake up. This is not normal. I mean, this is very bad.
Thank you.
Committees that you've mentioned. The research committee, do I correctly understand that it is strictly data collection, or does it issue information or any guidelines on definitions, criteria, protocols, or is it the ERCs that do that, or neither of them?
No, the ERC is the review committee, and the research committees are the national research committees every 5 years. So the review committees come after the intervention, the consultations come prior, and there's mandatory reporting. So all that guarantees that the data are to a high level valid, and they are complete. Now the data are anywhere between 75 and 80%, and they started out in 1991 was 18%. So I always say, when I say 80%, people look at you, shouldn't it be 100%? The answer is yes, but I have two answers to that. In your country, it's 0%, and sometimes physicians do not participate in ending life, but they do not use the correct means, and patients die, and they feel they have not committed euthanasia. They feel they have intensified palliative care, and they classify it under alleviating pain and suffering, with the double effect, so to say. So it's not physicians are not 100% also let's say, entirely clear in that respect.
You used the term assessment with respect to research committees. The term ERC's review, again, is implicit that there is an evaluation as
Yes.
to whether or not this was done properly.
Yes.
Do these committees report on that question, whether this met the test? Do these committees set any kind of protocols for that future physicians or that physicians are compelled to follow in the future?
No physician is to, they do not make protocols, but they make an assessment. They make the assessment whether a given case is within the limits of the law. And what you have seen over the years is that there are shifts, not only cancer patients or severely ill neurological patients or patients with heart disease, heart failure, or patients with lung failure, but also psychiatric patients came into. And that's what physicians did together with their patients and with the blessing of a consultant. And the committee said, yes, this is within the limits of the law. So they do not set new policy, but they validate or not what goes on. And so far they have validated quite a number of those developments with respect to psychiatric patients, Alzheimer patients, and the accumulated diseases of the elderly.
Can I just ask, just to clarify, this review happens after death
Yes.
and then what do they do if they disagree? You know, if they said this was outside of the limit of the law, that's when they kind of do some form of discipline?
Then they have two options. Mm-hmm. They have an obligation to report it to the prosecution.
Okay.
And the prosecution has the option to start criminal procedures or report to the medical inspectorate. And the medical inspectorate is an oversight, state-based medical oversight concerning the quality of healthcare. Because in effect what went wrong and what most of the complaints or most of the cases of not
refusing or
not prudent, they were not well. Most of those cases were minor issues that turned out to be minor. For example, a consultation procedure was not correct. And when the committee looked at the medical data of the patient, they saw that this really could have been different with that respect, but given the medical facts, there were no, let's say, no real criminal reasons. There was no criminal fact to be established.
Yes.
Yes, Dr. Kimsma, I want to ask you a personal question. Before the chairman of the board, the author of life, your origin and your destination, decides to pull the string, would you personally terminate your existence just because you cannot cope with your lot in life?
Well, that's a difficult question. And to be very honest, we are at the religious level, we are not on the same level. Because I've lost my faith during my active life as a physician. I've grown up as a Dutch Reformed, you know, those are not the most lenient approaches in life. But I've lost those connections. So I don't follow your invitation to reflect on how I would approach my creator. But I would what I would do personally, I'm not sure. That's what I've said all the time. If I would get a disease, I'm not sure whether I would want euthanasia or not. I think I would, but it's very easy to take a stand here and then when you're healthy, but it's impossible to make a final statement. You get there, you do something when you get there. I hope you understand.
Mm-hmm.
Yes, thank you very much. I think your story just now about the man who was told that he could not have aid in dying and should try oxygen, and later committed suicide, reminded me of a case I read about coming from Holland, I believe, from the Netherlands, in the last year, of a young woman, Milo de Moor. I don't know if you might have read about that one. It was in the various newspapers, describing a situation in which she was approved for medical aid in dying, and her physicians later changed their mind and said, actually, no, and she went off and she killed herself. So both these cases raised to me sort of the inverse of the way we normally look at this as lawyers. We think about the liability of physicians who improperly provide euthanasia, but both these cases raise the question of the liability for not providing it, or the circumstances under which it's denied. And I wonder if you have any reflections on this type of case, if you might know any of the details. I've been looking like mad, but speak no Dutch, so I can't find out what might have happened in this case, because I understand that the family of the young woman who came upon her body sued the physicians for the trauma of the way things unfolded. And so it puts things in slightly the different order in terms of liability and legal responsibility.
Yes, that's a very interesting question, actually. It has been my take and my conviction that if you hear the description of a case, that you really cannot make any judgments. You can only do it if you are familiar with the facts of the case. And then you have to get all the medical papers. You have to talk to the people who are directly involved. So I've learned to shut up and not be...
That's very wise.
But well, not all the time.
Me neither.
You can ask my wife about it. But the liability the issue does not exist in Holland because you have the right to refuse. If you have the medical, you've made the medical decision that after balancing pro and con, that you will not continue, then that is completely justified and accepted. And if the fact that the person kills herself or himself afterwards testifies to the unbalanced position or character or personality of that patient, and so it's not always possible to make the correct assessments of what will happen. So there are no legal ramifications, so to say, even though it sounds almost like ambulance chasing, what you're talking about, I mean, at least from my Dutch perspective. I mean,
Perhaps, although I understand from the newspaper accounts that I read that it was the family that had, in Holland, had initiated the legal proceedings there. So someone had told them there was some sort of basis in law to make a complaint.
Yes, well, but nothing has come out of it. Otherwise, I would have known.
Okay, thank you.
Okay.
Yes.
Gordon DeVal. Thank you very much for your talk, Dr. Kimsma. Very interesting. And I'm interested in, perhaps this question can be answered quickly. I'm interested in this idea of trusting that the Dutch system trusts physicians more and the Canadian system is perhaps more, criminally focused or more suspicious, perhaps. As you no doubt know, the Supreme Court in the Rodriguez case was very concerned about abuse and protecting vulnerable people from abuse. And it seems to me this possibility of abuse and this idea of trust may sort of interact. I wonder if you found any, and of course abuse was not just for physicians, but also family members or caregivers or others as well, this concern about abuse. But I wonder if you can tell me whether the Dutch experience of greater trusting, to the extent that's true, has had with it any reasons to doubt that trust or seen greater abuse or mistakes or something as a result of that trust?
Well, the issue of abuse is quite an interesting issue, but especially in America and in Canada. Because, first of all, physicians don't like to do it. If you're a physician who likes to do it and there may be reason for abuse, you should not be there. Your role is with compassion. And I had some more to present on the doctor-patient relationship, but the fact is that if a patient has a request to a physician to be helped to end life, that changes the physician, because you have to do something that is fundamentally not wrong, but that's fundamentally ambivalent. You're not no one is allowed to do it except we as physicians, you now here, and your nurse practitioners too. That's one. And in the second place, a more formal one. There has to be a request. That request has to be repeated, and it has to be found in the medical charts. It has to be found. So these two make the vulnerability to a non-issue. You really want to know if a patient has been influenced, for example, because of I can point out to you that the doctor-patient relationships in family medicine are often long-term relationships, and that doesn't always guarantee objectivity, but at least you get to know your patients. So it's not having to deal with a stranger, but it has to do with someone you've known for many, many years. And that also is a safeguard against these wrong conceptions.
Thank you very much.
Okay.
Hi. I was left a little bit confused around the situation of advance requests and patients with dementia, because I thought I heard you indicate that at the time that the death is administered, the patient is still competent or capable of at least communicating the continued will or desire for euthanasia. How does that, I'm confused as to whether or not it's possible, it's by advance request for someone who has actually lost capacity at the time of the death.
Yes. Well, the reason for confusion, well, the idea that you're stating is correct. The idea was to have patients with full-blown Alzheimer have the option to write an advance directive and to be helped when they had reached that stage. But the last line of the conditions in Article 2 is the other conditions apply mutatis mutandis. And one of the major conditions is that there is a consultation. And during the consultation, there has to be communication. Otherwise, a consultant cannot underpin that the conditions of the law are being fulfilled. So there has to be communication.
Communication of a request?
Communication about the request, communication about the competence, to make an assessment whether this patient, even though it is rudimentary, it may be limited, but whether this patient understands what the patient wants, has requested, and what the consequences are for that patient. Those are the steps you have to be sure about. Otherwise, well, most physicians won't do it. But I'm sure there are physicians also who have different opinion, who feel that they could continue with it, but if they report to the review committees, they run the risk of finding a conclusion of not without due care, or not with due care.
Thank you, that's helpful.
Okay.
Over there, and then we'll, thank you.
Hi, I'm Dominique Menard. I am the president of the Health Law Student Association here at Ottawa U. And I was just wondering how well we can compare, medical assistance in dying in the Netherlands versus Canada when we have really different populations and demographics and different political climates even.
Well, that's also a very interesting question. I think you are more in the position to be able to answer that. I'm always amazed when I look at a map. If you look at the size of Holland, it's comparable to the size of the state of Rhode Island in the United States, one of the 50 states. So it's probably your country is 200 or 300 times larger. The distances are unbelievable. When we drive for 4 hours, we are in Paris. So it's we have physicians. In my village, there are at least 10 physicians who you can easily refer to if we have one refusing physician. So communications are much easier, and the distances make it much harder for whatever you do. So it will be a challenge to find out how high a quality of it at the end of medical aid in dying you can really reach, you can really produce. That the Dutch cannot give you any advice except for what we have in our experiences, but those experiences do not compare to yours in the aspects I mentioned. So you will have to find your own ways, so to say.
Thank you. May I invite the last question?
No pressure there. Hi, thank you very much for an excellent presentation. My name is Randy Zlotnick-Shaw. I'm from the Hospital for Sick Children in Toronto. I'm wondering if you could spend a little bit of time and talk about the evolution of perspective related to granting access to young people, whether it's mature minors or children beyond that, providing access to MAID.
Yes, you've seen in the description of the advance directive, that's a person of 16 years and older. So that has to do with, in our system, someone of 16 years or older is medically mature, is capable to make decisions, even when parents would not appreciate it, and sometimes even when parents still bear the cost for medical interventions. These patients of 16 years and older can make their decisions. From 12, so they qualify for medical aid in dying after consultation with their parents. From 12 to 16, if a child wants to die, the patients have to agree. If the parents have to agree. If the parents do not agree, then the physician is not free to continue. And beneath that, there's you've heard of the Groningen Protocol,
yes.
maybe? Huh?
Yes.
That concerns neonates, but pediatricians also have adopted the same procedure. They tend to find out with the judicial authorities whether a case that might end up as a case of medical aid in dying qualifies under, let's say, the major law, whether it's comparable. And what we see in effect also that very often children die through palliative sedation. And that's what you do also.
But is there a lot of public debate, or has there been a lot of public debate? I know in environments that I'm at, people right away say, oh, if we're talking about mature minors, that's a whole different thing. And then there are others who say, no, we do allow mature minors or capable young people to make other decisions that lead to their death, so it really isn't on such a hugely different category. I'm wondering if that was a comparable experience in the Netherlands.
We didn't have much debate about the children in Holland. Less than in Belgium. Belgium, they had made a special law for children. So children now can ask for it, and even if they are 6 or 7 years old. But the idea is that pediatricians are the people who are capable, the physicians who are capable to make an assessment whether that child is competent in the request or not.
Thank you very much.
You're welcome.